the rules of the living trust work as a funnel to set it all through. Okay? So it's not enough, whatever you do, to get these pieces of paper, will, trust, medical power of attorney, I don't care what it is, and stick them in a drawer and forget about it. Because it all has to line up or you'll lose that game of tic-tac-toe. And you won't win the game. So one question that comes up regularly is, can I name my kids as the joint tenant on my house so I can avoid probate? Yes, you can. But let me tell you why you might not want to. Okay? First off, when you name your kids as joint tenant, you are assuming who is going to die first. You are. What if your child dies first and you're stuck back going through probate anyway? Okay? Somebody said, it happens. Okay? And I've seen it happen. Okay? Another thing I see happen regularly is you name one child as joint tenant, thinking that they're going to share it with their siblings. Everybody's going, oh no. Even if they do, because I get a lot of nice families. Most of my clients are really nice people, but they're like, I have to tell them the bad news. When you share it with your siblings, you are making a gift. And if it's over $11,000 a year, we're going to eat up your coupon for what you want to leave to your spouse and your family. So the other thing with joint tenancy is as soon as you give it to your children, you're making a gift. As soon as you put them as a title, on the title, you're making a gift. There's two issues with that. First, if it's over the under the radar limit, you're starting to use up your coupon. Second, now when you die, they won't get a full step up in basis. So that leads us to talking about capital gains. Okay? What happens when you die owning a piece of property is that the person who inherits it does not have to pay capital gains tax on it if they sell it for the same amount as what it was worth when you died. So let's look at an example. Let's say I have a house and I paid $100,000 for it. And when I want to go sell it, and I sell it for $200,000, how much is my capital gain? $100,000, because I only had this $100,000 basis that isn't profit. Now if I wait and I die and leave it to Derek, let's say, and Derek goes to sell it for $200,000, he doesn't have to pay any capital gains because he got a step up or a jump to the basis of what it was worth when I died. So if he sells it for $200,000, it was worth $200,000 when I died, there's no capital gains tax to pay. If he waits until it's $250,000, he's going to pay $50,000 tax on that $50,000. Now, if I name Peggy as my joint tenant, and then I die, how much is the step up in basis? How much did I actually leave to Peggy at my death? Really only half, because she already owned half, right? She was already half an owner on that title. So the step up in basis is only going to be half the value of what I died. So Peggy's going to have a capital gains tax problem if there's any increase in value of the property that I would have otherwise had to pay. So that's an issue with joint tenancy. Let me give you, and sometimes joint tenancy doesn't work out. I had one client who came to me after the fact. Her mother had died. No, his mother had died, sorry. His mother-in-law had died because the mother-in-law had named her daughter and her as joint tenants. So they each owned half. And I think that was what they intended. And then the daughter died. So now the mother-in-law, who's living in the home, owns it with her son-in-law because he inherited his wife's property. Now, he's a nice guy. He went and he transferred it to his mother-in-law. It's all hers again. But who got benefit out of that? I did, because I had to make it happen. That wasn't what they had in mind at all. So you really have to think about that joint titling stuff. And let me tell you about something that might serve your purposes instead. It's called a beneficiary deed. A beneficiary deed is very new under Colorado law. We've only had it since July 1st of last year. And it works like your life insurance or your 401k. You know, your 401k, you get to use it now, but you've named someone to receive it at your death, and you can always change your mind about that beneficiary, can't you? Well, it works like that with the beneficiary deed. You can do a separate deed that says, at my death, I want so-and-so to receive this. They don't get ownership of it now. They can't control it. They can't keep you from selling it or burning it or giving it to the Hare Krishnas. But when you die, without going through probate, it will go to the person named in the beneficiary deed. Okay? As far as I know, Colorado is the only state in the union that has done that. So you can't do it without estate property. And there's some big reasons why you might not want to do it. And I'm going to hit on one of them, and that is if you ever think you or the person you name in the beneficiary deed might need to go on Medicaid, you're screwing up their Medicaid eligibility. You're screwing up your Medicaid eligibility, and you're screwing up theirs. Because once you have a beneficiary deed, you could revoke it if you were well enough, but while there's a beneficiary deed on your property will be counted for Medicaid. Where if you didn't have a beneficiary deed and you were living in it, it wouldn't be counted for Medicaid. So don't do a beneficiary deed willy-nilly. But we're doing more and more of them because they do suit some of our clients' needs. The gentleman who asked the question has a revocable living trust. He did it in another state a number of years ago, and he wants to know if Colorado law is so different that he should have it changed to a point with Colorado law. I'm going to give you a two-part answer to that because you gave me a two-part question, so it's only fair. The change in law from where you come from, New Mexico to Colorado, is not a sufficient reason to redo your trust. Colorado is a very lenient state, and pretty much whatever worked over there will work over here. Okay? Not so much the case if you move out of Colorado and you move to, say, Florida. Florida has some very funky laws, and you'll want to make sure that it's reviewed so that it'll be effective in Florida. The other part of the answer to that part of the question was, but you told me that it had been 10 to 12 years. You might want to just look at it because things have changed. Your life has changed. The law hasn't changed a lot. Your lawyer may know better things than they did before. So it's always a good idea to review it a little more frequently than that. But the change in state is not a reason by itself. Okay? The second part of that question regarded IRAs. This gentleman remembers that he has named his wife as the beneficiary of the IRA, but somewhere in the planning they explained to him that his wife could decline being the beneficiary and it would go somewhere else, and he didn't know how that worked. In the law, that's called a disclaimer. Okay? And what a disclaimer is a legal no thanks. And it's really a pretend I died first. So if I leave my money to my husband Derek, he has the option, he always has the option of going, nope, I don't want it. Pretend I died first. What he doesn't have the option of doing is saying, and I'd like it to go here. He doesn't get to decide where it goes if he died first, even if he's not really dead. So in a disclaimer provision in your will or trust, we write and say, well, my first choice is my spouse. But if they disclaim, I want it to go over here, to a trust for my spouse, for example, or to a trust for my children, or whatever. So that's what a disclaimer does. Does that help? But that's not something your wife would do until after you died, and she talked to your financial advisor and your lawyer, and they told her it would be in everybody's best interest, including hers, to say, no, thank you. But you can only do that within 9 months of the time that you otherwise had control. You could have gotten it, inherited it, and you can't have gotten access to any of the property first. So she can't take a little bit of your IRA and then say, no, thank you. Once she takes control, she can't change her mind. If I don't own any real estate, all I own is a car and the stuff that's in my house, will I have to go through probate? And the answer is probably not, unless you got a really fancy car. Let me tell you the probate limits, okay? What has to go through probate is any amount of real estate. And I mean any amount. So if you've got an oil and a gas interest that's paying you $300 a year, you're going to have to pay me $1,000 to probate it. So get rid of it somehow, okay? Put it in the living trust or whatever. Any amount of real estate or $50,000. So if you've got a car that's worth 10 and a bank account that's worth 2 and the stuff in your house is worth 3, we're not hitting 50. So then we can do what's called a small estate proceeding, and it doesn't go through the probate process. Now, it might still be a great idea to have a will, because one of the things a will does in that context is tells us who should be in charge, right? If I've got 2 kids and I want to make it clear that they're not going to fight about it, a will help give them instructions about who should manage my affairs, even in this small estate. The question is, if a trust should